Good evening, chat. Hello. It is part 2 of the Richard Allen appeal that we're going to get into here. So welcome, everybody. Hope you're all doing well. And let's see here. Who had to say this? Edward Scott. Oh, so close, yet so far away. You know, that's got to hurt, and that's okay. That's okay. We all can't hit a home run every time. I hate this. Why is this not lined up right? Okay. Stupid. All right, there we go. That's how I want it set up here. So we're going to go like that. And I need to set this up as a preset then. Hold on here, guys. There we go. We got this one, and now we're back to this. Perfect. Perfect. My apology for snorting on stream, but yes, so close, Edward, but so far away. Now, guys, we're finishing up Richard Allen's appeal brief, and I know we talked about this a little bit already. What are his odds? Well, his odds aren't very good, and that's just the nature of how appeals work. They're really hard. They're really hard. Like, the odds are tough, but you do it anyway because you got no other choice. And I know some people were worried about how they're attacking things, and I think they're doing it the right way. Oh, hold on 1 second. Chat, give me 1 minute. I'll be right back. I know I was muted, guys. But cheese. Cheese and rice. Cheese and rice. I had to go take care of something. No, this is Sean. Sorry. Had to go take care of something. Yes, I was summoned to go do something. I had to clean up the kitchen after making the sandwiches. Well, shh. That's our secret. And then Kathy, you're a realtor in New Jersey. Remember, guys, if you're buying, selling, leasing, renting, you want to do a life estate subject to a condition subsequent, a fee tail subject to complete divestment. Kathy is your person in New Jersey to help you out with that, guys. Get a hold of Kathy. It's just for $20. Thank you, Kathy. He says, why did Richard Allen's attorneys get removed from the case initially? Because Judge Gull's incompetent, and she doesn't like the fact that she's a control freak and things weren't going her way. I mean, she's a very fickle woman, it sounds like. There was no real valid reason for those guys to be removed initially. It's because, she didn't like them. I mean, really, that's it. I wish there was more to it than that, but no, it's because Judge Gull's an asshole. Really. Sorry. I wish I could tell you more on that. Can that play into a new trial? No. Because the remedy, the court ordered the remedy and the remedy took effect. And then we didn't have a trial for like 10 months. Now, if they've been put back on the case and they had a trial 2 months later, yeah, that could be a problem. But we had that happened in January. They came out the same day with the order. And then November, we had the trial. So, no, I don't think that would, it's not, that wouldn't affect it. And I know his attorneys looked into it and they decided not to really go forward on that route. Now, I think that's, you're being a dead horse because the court's like, we already fixed that problem. And courts generally have the idea that whatever curative they do is good enough. And you're like, but wait, probably isn't. And they said, we don't care. Kind of like jury instructions. We told the jury not to consider it, therefore they won't consider it. You're like, but that's not how that works. And they're like, don't care. Deal with it. And you're like, all right, well, I guess we suffer. So, no, I don't think that would change anything. Also, Happy New Year to you too, guys. Happy New Year to everybody. Stebby says, I see Sean's gone full Hassan mode. Well, I didn't leave the chair running, so I'm sorry. Sleuthy Goosey, I think I saw you here. How are you doing, by the way? Merry Christmas to you guys. Another says, I didn't know judges could do what? Judges could do what exactly? Don't electrocute the dogs. Never. We will never do that to the doggos. No, we'll never do that. But as I was getting to, the issues that are raised here are issues that were raised. Yes, at trial they were objected to, but ultimately they're all pre-trial issues. The admissibility of things that Judge Gull denied right off the bat. So it makes sense that, do I know the Browns or the Steelers are playing? Yes. And if I don't watch the Browns, they'll probably win. If I watch them, they're going to lose. That's why I don't watch them. But when you get back to all these things that happened here, a lot of this happened right off the bat. The Frank's motions, the motions to suppress, all these different things that kept happening. It's all pre-trial. And if you win pre-trial, the case is done. Case is dead. Like if you throw out the warrant, this case pretty much dies. Because then everything that stemmed from the warrant is gone. So I understand why they're attacking it. And I think this is the smartest way to do it. I know some people are upset that they didn't go after Judge in the trial as much, but remember, a lot of that comes down to an abuse of discretion standard. And courts are very appellate courts are very deferential to a trial court as long as it wasn't completely stupid or retarded. And even if it was retarded, they're not going to want to get involved. And remember, there's always that good old thing they got in their back pocket. Harmless error. So what? She screwed up. He's still guilty. They try to avoid going after the judges like that because there's so many other things they can do. The David, making law simple, nothing makes sense. Well, that's true. Nothing makes sense. That's kind of normal for life. But that is where I think there's a lot here. No, sir, is saying, can you follow along without the prequel? Yes. I think that it's, like I said, these are all the pretrial issues that happen. A lot of this where it goes and where it's surrounded around on this. Remnant says, I'm unfamiliar with this case. Who is Richard Allen? What did he do? Richard Allen was convicted of murdering 2 girls back in 2017 out in rural Indiana. They finally arrested. It was a cold case, and for some reason they stumbled across him again serendipitously back in 2022. The case has been a dumpster fire with a lot of police incompetence and what you might call misfeasance. A lot of people are calling malfeasance and how they handle the case. There's a lot of problems there with it. And Richard Allen ended up getting convicted of the murders, and his face is doing 130 years in prison. So, it's kind of garbage. Yes, this is the Delphi case. These are the Delphi murders. So that is where we are right now. That is where we are. And sadly, maybe he did it. I don't know, but I haven't been convinced. And I honestly think at some point police misconduct and the misconduct of the government should override it, and they should be forced to deal with it. But so far that hasn't happened. And honestly, guys, like I said, I mean, I agree with all these arguments, but what's the Court of Appeals going to do? Probably going to say oh, well, I said, you don't have to agree with it, but that's probably what's going to happen here. So let's keep going, though. Let's get back into this. If you guys remember, we were on the last part here was Richard Allen's statements to he made in jail as he was sitting there eating poop. Remember, Richard Allen was sitting there eating his own turds as he sat in segregation in a maximum security prison. He sat in the maximum security wing of a maximum security prison. And he was eating his own turds, was hopped up on Haldol, all kinds of things. And yet somehow the court deemed all his statements voluntary and free from psychosis. Obviously, I don't think many here agree with that, but that is the argument. Now, they finally get to the idea that the error isn't harmless. Remember, harmless error is always what courts like to do when they want to, run away from a problem. And they point out that constitutional error can be held harmless. The court must find it was harmless beyond a reasonable doubt. And that's the thing, because remember, they're going to say, oh, well, it was harmless error. He's guilty anyway. We have to find that beyond a reasonable doubt. And they also point out, and this is true, no piece of evidence may have greater sway over a jury than the defendant's confession and his own statements. Yeah, those are very powerful. And they put out the erroneous statements to Dr. Walla alone were prejudicial because they were a large part of the state's case. And remember, they point out here, and the prosecutor particularly concentrated on his May 3rd statement, arguing Richard Allen knew a fact only the killer would know. But remember, it wasn't a fact the killer would know. Because Richard Allen also admitted to murdering his wife while he was on the phone talking to his wife. So remember, there's a lot of issues. The confessions also countered Allen's confident and unwavering pre-solitary protest of innocence. Yeah, it's sitting in the hole will break you. The court denied Allen, and this is where you get into Sixth Amendment issues here. The right to present a complete defense to explain the scene and impeach the investigation. You generally, you have the right to attack that. You have a fair opportunity to defend against the state's accusations. And Chambers versus Mississippi is a case I've cited before. They state for an opportunity to be fair, defendant must be permitted to confront and cross-examine and call witnesses in his own behalf. These principles operate in tandem with the Sixth Amendment, which guarantees a criminal defendant's meaningful opportunity to present a complete defense. And it says, although courts have discretion in conducting trials, this discretion has constitutional limits. Yeah, you can't just do whatever you want. And courts cannot infringe upon a weighty interest of the accused through decisions that are arbitrary or disproportionate to the purposes they're designed to serve. And they point out that the Judge Gold made several reversible errors under rules of evidence and the trial rules. And these also violated the Constitution as well. So when you deal with this, when you talk about admitting or excluding evidence, it's all for the abuse of discretion. And remember, that's always the judge. I'm ruling on this, admitted, not admitted, sustained, overruled. It's an abuse of discretion, which is a very deferential standard to the trial court. When there's constitutional issues, the courts review them de novo, meaning that they review it anew. They say errors in the admission of evidence are harmless if its probable impact on the jury in light of all the other evidence is sufficiently minor. Remember, this is where they say he was guilty anyway. There was a lot of other evidence. Even if the judge screwed up, all the other evidence that got admitted, hey, you know what? He's in trouble. Lisa, we just started. So that is kind of where we go from here. That was where we go from here. They say, but when the error is constitutional, the standard's higher. And they say before a federal error can be held harmless, and notice now we're having to get into federal courts. You know, the court must declare the belief that it was harmless beyond a reasonable doubt. And they point out the reversible error by excluding Blair's sketch. And this is true. It makes no sense why Judge Gull excluded the defense from being able to point out the guy you identified is not sitting here at this table, right? And you know, Betsy Blair would have to say yes. But the trial court prohibited Rick from using the sketch. You know, it violated rules and denied him the right to present a defense of mistaken identity. And yes, evidence is relevant when it has tendencies to make the existence of any fact more probable or less probable. And remember, guys, what I said, its relevance is the idea that does this piece of evidence, this item, this picture, this person's testimony, does it make it more likely the thing happened or less likely to prove the thing happened? Now, it could go either way because remember, either side may offer evidence. And if it does that, it's relevant. Now you get to then, is it admissible? Because relevant evidence may not be admissible. And it says a court may exclude relevant evidence as probative value. It's substantially outweighed by a danger of unfair prejudice, confusing the issues or misleading the jury, undue delay, or needlessly presenting cumulative evidence. So if I'm doing this for the 15th time, like I have 10 witnesses who all saw the guy. Or let's say there's 10 security cameras in an area. I may not be able to get all of them in because I'm now showing the same guy 10 times in a row doing the thing. But yes, Blair's sketches proved she didn't see Allen on the bridge. She did not identify Allen in court as bridge guy. Nobody identified Richard Allen in court as a bridge guy. The prosecutor never turned around and said, do you see bridge guy here today? The man you identified here today. They never did that because they would lose because the person would say no. And then if that person had said it, the defense could impeach them and say, does he look like this picture? No. This is the picture you said was right. Yeah. Did I ever get new pads for my headset? Yes. We had new pads. So. They said, but according to the prosecutor, Betsy Blair must have seen Allen on a bridge because Allen told us he went to the high bridge out to the first platform, which is exactly where She saw the bridge guy. Yeah, but she never went into court and said it's him. You know, the sketch shows Allen looked nothing like the person Blair saw just 3 days after the murders. Blair met with a sketch artist, described him about being 20, medium build, having curly brown hair. And yes, this is her sketch. That's not Richard Allen. But notice the prosecutor kept it out because this would have been fatal to their case. Somebody said, do I think, where is it here? Did Richard Allen learn about the, January 6th, 2.0 is saying, is it possible Richard Allen learned about the white van at his interrogation? Sometimes that happens, and remember, it's psychological manipulation when police are interrogating you. So could this have been an attempt to get him to think about these things? Sure, 100%. Could he have accidentally learned about it that way too? Yeah, I mean, there are a bunch of different ways he could have learned about it. Maybe even guessed. I don't know. But it is entirely possible. And hold on, chat, 1 second. All right, chat, we're back. Sorry about that. Yeah, he got 130 years in jail, guys. So, no, Richard Allen's not getting the chair. He's only getting 130 years in prison, which is basically forever. So, no, it's not a Louis accident. That was all me an accident. Now, from here, this says this looks nothing like Richard Allen. And at the time of the murders, Allen was short, 44 years old with closely cropped hair. Yeah, did not look like that guy at all. The sketch also shows that she and Carbaugh saw different people. Yeah. The state's timeline for the murders depended on Carbaugh and Blair seeing the same person. And the prosecutor told the jury that every eyewitness is adamant that the person they saw was Bridge Guy. There's no doubt in their minds. And these witnesses all said that, but remember, the sketches were kept out. But Blair's sketch proves the claim. Carbaugh, like Blair, made a sketch. When Blair saw it, she described it as wrong and not who she saw. Blair's sketch impeaches the investigation and shows law enforcement bias against Allen. It says, for 2 years, they circulated Carbaugh's sketch without it yielding a single arrest. So in 2019, they released Blair's sketch and declared it represented the face of Bridge Guy and announced that Blair and Carbaugh did not see the same person. And it says, after Allen's arrest, the story changed and the jury was told Carbaugh and Blair saw the same person. Yeah, they suborned perjury. The sketch was... they say Blair's sketch was reliable and probative of the identity. Yes, it's true. And it was very clear that to her, this is Bridge Guy. And 2 days later, she developed her sketch with an artist. She rated her sketch 10 out of 10 for accuracy. In 2019, she met law enforcement and she reaffirmed her confidence. She insisted she could identify Bridge Guy if she saw him. And notice, at trial, they never said, Miss Blair, is he here today? And she went, and she didn't go, right there, that's him. No, that never happened. That never happened, chat. Say, Blair's sketch is not hearsay, and it's true. This is how Judge Gall got rid of it. She claimed it was hearsay. Now, yes, hearsay is an out-of-court statement being used to prove the truth of the matter asserted. And they say the sketch was not a statement. Yes. Although Indiana has not reached the issue, other courts hold that a sketch is the functional equivalent of a photograph. Yes. No statement is involved. A sketch is not hearsay. I agree. The sketch is not hearsay if the declarant testifies and is subject to cross-examination about a prior statement. And yes, if the sketch is a statement, she can be cross-examined about it. It's an identification shortly after perceiving that person. Yeah. Days later, not weeks, months, years, days later. Now, the rule applies whether, regardless of identifying witnesses, make a positive in-court identification or not. And they say here, Betsy Blair identified Bridge Guy and immediately gave her sketch. Her sketch is also admissible as an adoptive admission. And a statement's not hearsay when it's offered against an opposing party and is the one party manifested that it adopted or believed it to be true. She said 100%, this is the guy I saw. It's 100% me. Yep, and that's true. She was not asked to identify, and that's what I mean. She didn't get put up there and said, is he here in the room today? Nope. She said, did you see a guy on the bridge? Yep. Did you give him a sketch? Yeah. Is that sketch correct? Yeah. That's all they talked about. And they say her sketch is admissible under Indiana common law too. And this says decades before Indiana adopted rules of evidence. Sketches were admissible if the eyewitness took the stand at trial. And even if it was an inadmissible hearsay, Allen is still entitled to use it. State law doesn't have the last word, yes, and the rule must yield to the right to present a defense. And it ultimately has the right to confront his accusers. And they point out it's crucial if you're defending on a claim of mistaken identity. And the right cannot be abridged through the application of arbitrary or disproportionate rules. And they say excluding the sketch violated the Constitution. Here the state concedes Bridge Guy's identity was crucial to the case. And it says if we can determine who Bridge Guy is, we can determine who killed Abby and Libby. They say the sketch was critical to Allen's defense of mistaken identity. And the decision to exclude it was arbitrary and disproportionate. I agree. I don't think the court's going to go along with it because it's going to say here's what's going to happen ultimately. It's probably going to say the confessions were wrong, but the sketch is okay. Or the sketch is wrong, but the confessions are okay. And they're going to then say, harmless error. I really think that's where it's going to go. I would love to see him get a trial. I just don't think he's going to get it. Did the defense ask her to identify? I think they were prohibited from doing that. I believe they were prohibited. The error is harmful under both constitutional harmless error and then he has evidentiary standards. They say there's no dispute the state's timeline depended on Blair seeing Allen on the bridge and Blair and Carbaugh seeing the same person. And the sketch disproves both points. Excluding it affected the rights here. Then going on to the firearms examiners. The judge excluded this guy because he was not a firearms expert. He was untrained in firearms identification. He did not examine the evidence, and he did not conduct a firearms examination. And they say, according to the court, the testimony does not go to an issue before the jury and lacks relevance. And remember, guys, part of the issue with Judge Gull is she would just issue entry orders the whole time. She refused to write out an opinion, and finally she did. And they say they point out this. They say that ultimately expert testimony should be admitted if the expert is qualified by knowledge, skill, training, experience, or education. And this is one I think they're going to lose on. Allen's going to lose on because these are big points. He's not a gun guy. He's untrained in firearms. He didn't examine the evidence, and he doesn't conduct a firearms examination. Now, he could talk about tool marks and how they're bogus, but yeah, I don't think this one's probably their weakest one here. Now, they point out that, the testimony will help the trier of fact to understand the evidence or determine an issue and affect an issue. And ultimately, Indiana adopted this rule to liberalize the admission of expert opinion because Indiana's like, we need more experts. We want to bring them in. We want them to help us. Now, what can he say? Well, he was clearly qualified to explain the scientific community's robust and tangy criticism of the AFTI methodology. Tubin is a nationally recognized expert in forensic metallurgy and material science who has testified as an expert in many cases involving the validity and reliability of firearms and tool marks. He has extensive experience in metallurgy, bullet and lead analysis, and tool mark principles, along with a background in statistics. He understands the President's Council of Advisors on Science and Technology, which is a thing that is a governing and watchdog body, which has issued a detailed report criticizing the American Federation of Toolmark Examiners methodology, which it is. It's sketchy. Toolmark stuff is really tough. And they say Tubin's testimony was essential for assessing Oberg's credibility and determining what to believe. Once that expert takes a stand, their credibility is fair game for impeachment. And a party is free to challenge the methodology with opposing testimony. The jury is ultimately responsible for assessing witness credibility and determining what to believe, and that's true. And I said here, Oberg testified she matched the tool marks on the test firings with tool marks on the unspent cartridges found at the murder scene. She told the jury she found agreement between the tool marks by using AFTI methodology. She gave an error rate of 2.2% for false positives and 2.87% for false negatives. So about 5% total. She discussed the studies and articles that she reviewed to apply it, and over relevancy objections, she described the studies relating to guns that were not even the Sig Sauer, and it was meant to be a 229, although I believe it was a Sig Sauer 226. But yeah, that's just a mistake there. A lay juror might find this testimony impressive and can hear it, but the methodology is anything but straightforward. And they're saying Tubin's experience would help a jury understand the scientific community's criticism of the subjective methodology and force Oberg to engage with that critique. They go on to state here a little further. I agree. I think it's absolutely horseshit. Most of this tool marking stuff, comparing fired cartridges to unfired cartridges, you can't because they don't have the same marks and stress and events that have gone through them. One of them literally had an explosion detonated inside of it that has been extracted under significant force. I mean, like the forces in a firearm can rip the head off of a casing clean off. So the idea that she can tell anything about this is absolutely garbage. In terms of saying it's credible as aspirant reading, no. Yes and no. The times that tool mark examination and tool mark analysis would be helpful are going to be times where it's very obvious to everybody in the room that it's the same tool. Like there are nicks and dents and machine defects in the item. But basically, like you can take the knife and put it up against the skull, and the dents on the skull match the dents on the blade. That's kind of those times where, like, okay, clearly this was it. But you don't need an expert at that point. And I say, even if our rules tolerated the exclusion, the decision was patently unconstitutional. The defendant is entitled to a meaningful opportunity to present a complete defense. This entitles him to impeach a witness who provides a crucial link in the proof of the defendant's guilt. And they say that while the courts have broad discretion, you can't do it to arbitrarily exclude competent, reliable evidence bearing on witness credibility when such evidence is central to the defendant's claim of innocence. Yes, I think so, and I think that's correct. Now, ultimately, like, let's say the other thing, we'll talk about this later. We'll talk about it later. And they say here, Oberg's credibility was central to the case, and the judge arbitrarily excluded Tubin. Tubin is an expert in their methodology and its shortcomings. He has experience with firearms identification, and he examined Oberg's materials. There was no legitimate state interest in excluding Tubin. And it said Allen did not waive his right to appeal the Tubin issue by calling Warren. And a party aggrieved by an evidentiary ruling is entitled to respond to the improper ruling without sacrificing the right to appellate recourse. And they're already, this is them heading off a prosecutor argument saying, well, you provided somebody anyway. Yes, we provided somebody as a backup alternative. Once a court excluded Tubman, Allen responded by calling Warren, who endorsed the use of AFTI methodology, and engaged Oberg in a battle of experts over how to properly apply the methodology. This did not waive Allen's right to appeal, and they're just kind of going forward on that just to show that. They say the error is harmful under both the constitutional and evidentiary standards. I agree. I think so. It's absolute horseshit. The state told the jury Oberg's never been wrong and that Allen has no explanation of how his bullet from his gun ended up between the bodies. Well, that's not what he said. And here's the problem. If Allen hadn't answered anything, then they can't use anything against him. They can't take your words and twist them. They can't do all the stuff that happened to Allen. So that's why you don't talk to the cops. They say, had the jury heard Tubman's robust impeachment of the methodology, the outcome of this case would probably be different. I don't know, man. Even if you put this in there with the confessions, I think he's fucked. You have to get the confessions out or he's completely fucked. If you can kill the confessions in the warrant, then yeah, it's game over. But it's not as straightforward here. But their argument is to argue for Richard Allen. And it says the court committed reversible error in admitting hearsay to rehabilitate the timeline upon which the state built its entire case. So the state built its case upon the following timeline. Allen encountered girls at 2:13. He completed the murders alone, left Libby German's phone at the scene, was spotted by Carbaugh leaving the scene at near 4 o'clock, and never returned. If Allen committed the murders, there should be no human-initiated activity on the phone after 3:56, but there was. At trial, Allen called Eldridge, a former FBI examiner, who examined the data from Libby's phone and testified that the wired headphones or an auxiliary cable were plugged into the phone at 5:45 p.m. and then removed at 10:32. This action would silence a phone call, and she noted the data showed an incoming call moments before the headphones were inserted, suggesting someone was intentionally silencing the phone. And they say since the state claimed Allen left the murder scene at 3:56, the evidence eviscerated the state's timeline and showed someone else committed the murders. Then the state responded, and this is where, yes, this is one of the things I think is absolutely insane. The state asked their phone expert whether water damage could simulate headphones being plugged into the phone. Over a hearsay objection, he testified that he Googled it, which is absolutely insane, and found some unspecified non-peer-reviewed troubleshooting forums reporting that it could. But at 5:46, it wasn't raining. At 5:45 on the 13th, there was no rain. Like, what weather event would have occurred that would make you think this happened? It wasn't raining that day. The testimony was an inadmissible totem pole hearsay, yes. Unless our evidence rules provide otherwise, out-of-court statements are not admissible for their truth. For totem pole hearsay to be admissible, each part of the combined statements must conform with an exception of the rule. And that's the thing, chat. If it's hearsay, within hearsay, within hearsay, within hearsay, within hearsay, within hearsay, however many levels of hearsay there are, each level of hearsay has to be admissible. Otherwise, because if you don't, then you can't get to the bottom and you can't use the initial quote. But you have to show how that all escapes the hearsay exception. So you have to have it every time. And that's the thing too, Skinrow. Prosecutors will say phone data doesn't lie, except here. Yep. And they put out here the troubleshooting forum posts are at least double hearsay. The internet forum and the statements posted there. Yes. And his status as an expert does not affect the hearsay analysis because Statements contained in a reliable authority, like a treatise or an evidence manual or a published book, can be admitted over hearsay when used to contradict an expert who is testifying on the witness stand. Now, here's the thing. Let's say if you try to impeach a witness with some random shit off the internet, he's going to say, well, that's not peer reviewed. I don't know what that is. Who knows? Maybe. And they say the expert, the expert who's testifying on the witness, they say, but here the online form is neither reliable or used to contradict. And that's true. Rule 703 does not avail the state either. Under Rule 703, experts may testify to opinions based on inadmissible evidence if the evidence is of the type reasonably relied upon by experts in their field. The rule doesn't authorize experts to parrot facts that the expert adds nothing to. And he didn't add anything to this. He was a mouthpiece for something that he Googled. And the error is constitutional. And I think this is actually more important than critiquing the expert in guns. I think this is far more important. I don't know why you kind of organize your strongest stuff first and you go down the list. I think this is far, far more effective, ultimately, in my opinion. And the defendant's entitled to a fair opportunity to defend against accusations, which include the right to impeach a witness when they provide a crucial link in the defendant's guilt. And here the judge allowed the state to undermine testimony with an internet post, and it was impossible for Allen to impeach the person through cross-examination. Because how do you cross-examine a random post on Reddit? The answer is you can't. So all he's going to say is, well, I read it on there. I don't know anything more. Why are you relying on it? Well, it's a thing. Are you telling me that it's wrong? This is the problem with using this stuff. They point out the error is harmful. Yes, I think so. I think it was very harmful. I think it was very, very harmful. They say at trial, Allen sought to impeach the credibility of his confessions. It's another thing he was not allowed to do. And the judge made 3 reversible errors here. And these violate his right to present a defense. And it says, when somebody confesses, the manner in which the confession was obtained is relevant. And how did the court violate things here? Well, Allen tried to introduce 15 videos showing his mental state in solitary confinement. The judge sustained the hearsay objection and ordered Allen to mute the videos when he showed them to the jury. So these were all shown without sound. The audio shows, it shows a delusional, confused, and disorganized mind. No, it doesn't. Without the sound, you don't know what you're looking at. You just see some guy walking around like a goober. It's true, though. The evidence can only be fully appreciated by listening to it. Yes, you have to hear it. You have to hear it. Am I applying their falsehoods on the internet? Do you think that? Do you really think people would? It's like hold on. It's like the meme goes. Do you really think people would lie on the internet? It's yeah. Where is it? I love it when it's the dog one. But yeah, this is just as good. This is just as good. Yes. Do you really think someone would go on the internet and just tell lies? Do you think people would do that? Yes. Yes, very true. And they say, according, Allen respectfully requests his court to watch the videos with audio. Which, that's a bit of a stretch here. But yes, the court does have the right to review evidence. If they're going to review it de novo, they should have to watch them. The statements in the videos are not hearsay. Statements are not hearsay when used to prove a defendant's state of mind. That's correct. If he says I am the king of England, well, we're proving his state of mind. We're not proving that he's the king of England. They say this was precisely Allen's purpose in offering the evidence, and the trial court conceded this. And when Judge Gold said, well, I understand, but no. And it says there are older cases suggesting a defendant can never admit his own statements. And that's an older thing. A defendant can never admit their own statements. And that's an old rule. It's also like there used to be a long-standing rule you couldn't impeach your own witness. So if you called a witness up, you couldn't impeach them. Well, you could do that, though. You can do it. And hold on here. I got to move this. Sorry. Did I say Arthur? Okay, well, it's Buster. He's the rabbit. And this is inconsistent with the adoption of modern rules of evidence. Yes. And they say audio on the video is relevant because it impeaches Dr. Wallace's testimony and undermines her medical records. It says Dr. Wallace's evidence gave the misleading impression that Allen provided organized and detailed confessions with a beginning, middle, and end. But the omitted audio rebuts this, showing a disorganized, nonsensical, and confused Richard Allen. And they describe that Allen's mind is more organized than he'd been. But the videos put this statement in context, showing a disjointed, nonsensical, and rambling Allen. He is plainly psychotic and incredible, which I think you have to without hearing it. You can't do. The audio presents a vivid picture also of Solitary's harsh conditions. The staff talk callously to Allen. Guards remark how long crap has been on his back. Inmates tell him to kill himself. Medical staff ignores signs of serious mental distress and over-medication. In one video, the nurses and medical staff ask Allen about his cholesterol and blood pressure while ignoring his catatonia and drool, meaning he's just basically like a zombie. Without the audio, this presents a misleading impression that the professionals are attentive when in fact they're not. And the error is harmful because it shows Richard Allen's statements are unworthy of belief. And they say the trial court then committed reversible error, prohibiting the jury from hearing 2 phone calls Allen made in April. It says on April 2nd, Allen called his mother and discussed finding a religion. In the early morning hours of April 3rd, Allen made 3 intertwined calls. Over objections, the jury heard the second call where Allen confessed to his wife. But the judge prohibited the jury from hearing calls that bookended it, where Allen questioned his sanity and the veracity of his own statements. And they put out Trooper Harshman's testimony made the error only worse. Over objection, Harshman claimed that when confessing, Allen was consistently calm, subdued, and solemn in tone, showing no indication of stress or duress. But the excluded calls discredit this testimony. Allen was confused and forgetful. He believed he was losing his mind and that IDOC was poisoning him. He referred to as being mentally tortured, comparing his environment to Guantanamo Bay, which probably did feel like that. This whole trial should be thrown out. It should, but is it going to work, though? Is it going to work? I don't know. That's the problem here. That's the problem. Jerry 6 says, if the confession was presented at trial, wouldn't the fact he was in solitary for 13 months or at least 4 be, before confessing, be important? Not according to what was presented to the jury, because remember, the medical doctor said, "Oh, he's fine." Guess what the jury say? Okay, he's fine. So the state was allowed to bring in people who could say, "Nope, everything was okay." And you know what the jury says? Everything was okay. And then plus Mannequin Tanner says, will the state government be liable for damages if Richard Allen's case is overturned? Nope. Malicious prosecution and stuff like that, it's really hard to prove. And in this case, they're just going to go, oops, we got the wrong guy. Sorry. And you know what happens? Richard Allen gets to go home after they destroyed him mentally. So, nope, nothing can happen here. That's it. What happens is what happens. Oh, Manny. Okay, I'll call you Manny going forward. So. Now, they also point out that in closing, the prosecutor told the jury Allen started confessing because he'd given himself to Jesus the day before. The excluded calls tell a different story. Allen was losing his mind, lapses in memory, confusing dreams with reality. The prosecutor got to offer an inculpatory statement for how the confession started, while Allen was prohibited presenting the exculpatory story through contemporaneous evidence. Yeah. And then it said the trial court erred by excluding the statements of behaviors that provide the foundation for Dr. Grassian's opinion that the confessions were not credible. Remember, Allen's doctor says that he was suffering from delirium. But the judge prohibited that doctor, from discussing the statements that provided the foundation for it, including Allen's statements that were patently false. Why? Because she's an asshole. And that is reversible error. First, the false statements are not hearsay. You know, when he says he's the king of England, we're not there to prove he's the king of England. We're just going to say he said it. And then the jury's going to say, wow, this guy really believed all this stuff. And, you know, that he killed all these people and clearly he didn't. It's like, yeah, I don't know. Maybe we can't believe it. Because they want to show his state of mind and prove that he was saying things unworthy of belief. It says, even if you were to consider it hearsay, though, the statements are admissible, in which experts may testify to opinions based on admissible evidence. And they say, third, the statements were admissible because the state opened the door 3 times. Trooper Harshman testified that Allen's confessions were consistent and included details only the killer would know. The state also paraded to witnesses in front of the jury who opined that Allen's mind was intact when he confessed. And then Dr. Waller testified she saw no reason to screen Allen for delirium. And Richard Allen was entitled to counter all of this with his statements. That the idea that the statements were false, inconsistent with the murder, and consistent with delirium. And they say independently, this error was so harmful it warrants reversal. Yeah. This would have a significant impact on the case. Because even if you couldn't keep all of it out, you could explain to the jury, look, a lot of this is garbage. And you know what you'd think a jury would say? Yeah, we agree. Reversing. But they put it in closing, the prosecutor molded the story. The confessions were truthful. The judge affected the jury's decision when she prohibited Allen from showing he made repeated untruthful confessions. And they say these 3 things show that his constitutional rights were violated. Yeah. I don't disagree. They say Allen repeatedly presented evidence that places confessions into context and impeach her credibility. But the judge arbitrarily excluded them. Why? Because she's an asshole. Remember, Judge Gold's incompetent. And for some reason, she had it out for this entire situation, which we don't understand what her deal was. Nobody really knows. Nobody really knows what her animus was or why she acted the way she did. Like, it's still not clear, and I'd love to know why she acted like a complete dickhead in this case. And I'm sure she's going to say, well, she acted perfectly fine. And it's like, but you didn't. You didn't. The trial court committed reversible error in denying the motion to correct errors. Richard Allen filed a timely motion to correct errors, arguing the state elicited false testimony and allowed it to go uncorrected. The trial court denied the motion. They point out the 14th Amendment is violated where the prosecutors knowingly solicit false testimony or knowingly allowed to go uncorrected, which it happened here. They say, according to Dr. Walla, Allen confessed he was attempting to rape the girls, but abandoned his efforts and fled with them across the creek when he saw a van. At trial, the state elicited testimony from Brad Weber, who told the jury he left work at the Subaru factory around 2:02 p.m. and drove his white cargo van directly home. And the prosecutor told the jury the timeline and the confession and the stepdata matched perfectly. And they say the testimony ultimately was false and the state knew it. And they said specifically, The security cameras showed him arriving home around 2:44. And the cell phone data showed him arriving home around 2:50. They say this requires a reversal, and I agree. Error requires a reversal if it could have contributed to the verdict. Yes, and I think they did. This stuff all contributed to the verdict. It all contributed to the verdict against Richard Allen. It all did. Does the judge have a connection to the other suspects? No. But yes, there are some issues that the prosecutor, Nick McClellan, is a Mason brother to the other suspects. Yeah, but I don't believe there's some super secret governmental interdimensional pagan cabal pedophile sex ring going on. It's just they have a case, they ran with it, and they're going to say, be damned, we're not going to be embarrassed. That's why they stuck with this the way they did. Is Gull a pagan? No, she's just a tard. So, and they say here the false evidence, if corrected, would show that Weber's arrival home was inconsistent with the state's timeline. He arrived home 20 minutes after the pause on the phone, and nearly 15 minutes after the phone was on the other side of the creek and hundreds of yards away from his house. Thus, the statements are inconsistent with the truth. The truth! It suggests he was delirious. The error requires reversal. The trial court committed reversible error when it excluded the ritual killing evidence. She's not an Odinist. She's more like a Hodinist. They say the trial court prohibited Allen from explaining the murder scene as a ritual killing. Yeah. Evidence that tends to show someone else committed the crime makes it less probable the defendant did it and is by very much the definition of relevant. Here, Richard Allen used Don Perlmutter, a recognized expert in ritualistic and atypical homicides. And it says ritual killings commonly occur outdoors in wooded areas and near bodies of water. They occur on holidays significant to the group and often use ceremonial knives. There will be symbolism at the scene. And when Norse pagan rituals, the symbolism will likely involve runes, not moon runes, just runes, arranging natural objects in a specific way, and perhaps combing the runes with blood. And they point out you don't get bullet wounds with ritual murders. Rather, there's usually throat-slitting, blood loss, and perhaps torture. You expect the sacrifice to be displayed or arranged. Then finally, you would expect to see an atypical or symbolic blood pattern at a ritual killing. And guess what, chat? Guess what? And guess what? We got all that. And yes, this scene included all of these elements. They were outdoors in a clearing near a large creek. The murders coincided with the Nordic holiday Vallisblot, which honors Odin's son. The girls' throats were cut, and they bled extensively. Yeah, white girl bleed a lot, like the book says. The sticks are obvious symbolism and difficult to explain any other way. It says the stick arrangement mirrored the Norse rune Gabo. Gabo! It's gay, chat. And the stick formation on Libby looked like the Nordic bind rune. Still so ridiculous. I'm binding these runes together. I'm making words. It's like, how does that work? So cringe. They also said the bodies were arranged in a manner consistent with the pagan ritual. The upside down hanging body is an important element of Norse paganism because Odin hung from a tree for 9 days before discovering the runes. And Odin's leg is often displayed with one leg bent behind the other. They say here the blood patterns on the girls' faces suggest a person lifted their bodies, or articulated their torsos and necks above their chins. Yes. Abby's leg was bent behind the other, mirroring the classic image of Odin. And the blood pattern on the tree appeared to look like a Norse pagan Fehu rune. Then they say that Richard Allen's attorney had the knowledge, skill, and experience to offer this testimony. And once again, all these things, is the expert qualified by knowledge, skill, training, or education? Will it help the trier of fact, the jury, understand the evidence? Yes. Well, she's an expert in ritualistic killings, is a federal subject matter expert on atypical and ritualistic crime investigation. And she's the author of Ritualistic Crime Scene Investigation, a field guide for cops investigating ritually motivated crimes. And they say she teaches about ideological and ritualistic killing. She's familiar with the practice of Norse paganism or Odinism. She's qualified to offer her testimony. It was not conjecture. There was always a discussion that this may be a ritual murder, and the sticks were Nordic runes. And it says that they ultimately declined to exclude pagan ritual as a plausible explanation for the murder. A consulting professor found it quite plausible that the stick markings constitute an instruction inspired by Norse runes. I mean, this is the one we talked about before, guys, with the teacher saying whoever did this, they're an idiot. Like, they don't understand how runes work, but this is their best attempt at making runes work. So we'll see. We'll see what they do here. We'll see what they do here with this. But I think it's all great, but who knows? They say an undercover law enforcement also found pagan symbolism there. And they said this would be helpful to the jury. I think so. They said, although motive is not an element, juries want an explanation for a crime. And that's true, guys. Remember, motive has never had to be proven. But yes, as a jury, they're going to want to know why. Because it's kind of think about it like this. People don't just get randomly murdered generally. There's something behind it. Or if two guys get into a bar fight, it's never just simply, oh, I was just drinking my beer and some guy started punching me in the head. No. What caused that to happen? It's like Bill Burr says with the dog. Well, the dog bit me. What were you doing? Were you fucking around with it? How did that happen? No, I was just minding my own business. Nobody believes that. Nobody believes that. And when the motive is unclear or inconsistent with the guilt, juries are more likely to acquit. Yes, they are. When a murder scene is complex or unusual, it is important the jury receive the explanations. Yeah. They see here the murder scene was complex and unusual, and the jury would naturally want an explanation. And they point out the sticks immediately stand out to any person as unusual and warrant an explanation. Then it says Perlmutter's testimony provides an answer, explains the scenes, and offers a motive. And they say her testimony would be helpful to a jury. I think it would absolutely be helpful to a jury. And they say excluding her violated the Constitution. A defendant is entitled to answer the prosecution's case with his version of the facts, so a jury may decide where the truth is. And it's also helpful because he's not offering lies and bullshit. He's offering a plausible set of facts. He's not just like saying, oh, some Chinese spies came in and did it. You can't disprove it. Now, they point out the judge can't infringe upon this right through arbitrary, disproportionate, or mechanistic applications of the rules of evidence. And they say, according to the state offers inculpatory explanations for evidence, trial courts cannot use the rules of evidence to prevent the defendant from offering an exculpatory explanation. Remember, the state is inculpating you. The defendant is trying to exculpate himself. And it says, by excluding the testimony, the trial court allowed the state to offer an inculpatory explanation while denying Richard Allen his right to offer an exculpatory one. It's arbitrarily and disproportionately denied Richard Allen his right to present a defense. So ultimately, what's the problem here? Well, the prosecutors want to say it's a brutal murder, and they incriminated Richard Allen, and the jury received a one-sided explanation for the crime without Allen being able to counter it. Yeah, and the jury's like, well, this guy's not challenging it, so it must be true. That's what juries think. And ultimately, Richard Allen was prevented presenting any evidence regarding the manner, quality, and thoroughness of the investigation into this murder. And ultimately, you have the right to have your case proved beyond a reasonable doubt. And how can you show that there's problems? Well, you can show the investigation was incomplete, overlooked plausible leads, or law enforcement mishandled evidence relating to a third party's guilt. Yes, all those are reasonable doubt. All those are reasonable doubt, guys. And it says here, Allen presented evidence. The state performed an incomplete investigation, which they did. They mishandled and destroyed evidence, which they did, and overlooked plausible third-party leads with pagan rituals. They did. And it says, after examining the scene, several officers believed it was too complex for just one person to be involved. The sheriff immediately thought the sticks related to pagan rituals. And hold on here. The day the girls went missing, law enforcement learned that Abby was having a secret relationship with Brad Holder's son. You know, that's not a fucking red flag. That's not a red flag. That week, law enforcement viewed Holder and his friend Patrick Westfall. They hide Odin's spear inside of each other. Holder reported being involved in a pagan tribe. So cringing gay. And spending every weekend in Delphi engaging in pagan rituals with Westfall and 5 or 6 others, including women. Like, it's so gay. So gay. Holder told police he owned a .40 caliber handgun, just like Richard Allen did. But officers did not examine or collect the weapon, nor did they search his phone. Yeah, isn't that weird? Holder told police he was at work when the girls went missing, and law enforcement recorded over the interview, permanently deleting it. Yeah, it's all just oopsie poopsie. In his interview, Westfall told law enforcement he knew the woods in that area very well. He reported knowing the girls, but denied ever meeting them. Yeah, isn't that weird? He also reported being a religious leader. You know, for these local pagans, and he wore a necklace to the interview representing his efforts to pledge the Vinlanders, a pagan social club. Yes, and they're not just a social club, chat. You know, it's it is accused of, depending on who you ask, it is a white supremacist group. But it's if you want to know what the Vinlanders are, I mean, this is Vinlanders.org, which I think they might be able to say this is them. I would just say it's probably them if we're gonna go with it. Yeah, so it's federal agents pretty much. But here is the Vinlanders, Vinlanders.org. You know, it's a brotherhood built on racial loyalty, self-discipline, and strength. We're not a club for show, nor a crew chasing trends. We are a serious organization of men committing a code of conduct that separates us from the noise of imitation and the weakness of the world outside our circle. Our mission is to preserve the integrity of the brotherhood by living white power in the 14 words, which are principles that demand respect, honor, and accountability. I don't know why you'd put all this out there in put this all out there in on the internet like that. This is pretty glowy. I'm just saying. That's just weird. Just saying. It doesn't make a lot of sense here. These values are not empty words, but daily standards by which we measure ourselves and each other. I mean, if I'm not gonna lie, bro. If you're like, oh, we're preserving racial purity and shit. If a group of SS, like a squad of SS guys, rolled up on you in the woods, they gun you down. This is absolutely ridiculous nonsense. It's like Andrew Tate. If Andrew Tate tried to join the SS, they'd put him up on the wall. These people would get put up on the wall. Yes. Contact us at P.O. Box 426 69 420 Blaze It in Langley, Virginia. Yes. It's glowy indeed. Yes. We exist to forge strong men and unbreakable crews, with every state anchored by a single unit that carries our name with honor. Each member, from supporter to full brother, understands our structure is not a title, but a process of proving, earning, and embodying the brotherhood. We respect the path. We honor the patch. Oh, we got patches now. Oh, yeah. And we recognize what we built is bigger. Founded in 2006, Firm 22 is the Finlander Social Club support crew, open to both men and women, and represents the extension of the mentality as a force in unity that sets us apart as a club. We are not imitators. Yes, you are. We are originators of being gay. We do not waste time with pointless endeavors. You pray in the fucking woods and slaughter animals. It's pretty gay, man. Also, I'm a little disappointed. Nobody here in chat's wait, what are the 14 words? Everybody here in chat's oh, I already know those. Don't worry, Sean. It's oh, buddy. Oh, buddy. That is an indictment of you guys, not me. But rather we invest ourselves in building a legacy of strength, loyalty, and respect that will outlast trends and stand as a true example of a white power family. Okay. Yeah. Yeah. You just asked that? I didn't see you say that. Sorry. And real quick, January 6 says, so what other evidence that was ritual other than the police department's wishful thinking? The runes that were found on the bodies, the sticks were shaped like runes. Even college professors are yeah, this looks like somebody trying to be pagan. There's a lot of things there that indicate it. So a lot of things. But yes, if you guys weren't aware what the 14 words are, the 14 words are a common slogan in white supremacist circles, and it's we must secure the existence of our people and a future for white children. And I'm sure that's not going to get clipped out of context anytime soon, but that's what that's all for. To get active as a stand-up, get serious, and prove that it isn't just a name you wear, it's the life you live. White power because we are powerful. Okay. I like how they have a privacy policy. What's their privacy policy? The media. Let's see. They talk about who we share your data with. Everybody, because we're the feds. How long we retain your data? We're the feds forever. What rights you have over your data? Notice we'll do whatever we can as long as we're obliged to keep it for administrative, legal, or security purposes. It's very interesting, isn't it? Very interesting how that works. Alyssa already has it up. Oh, yeah. What's Firm 22? So this website has not been updated in years. Firm 22. And I like how they're using what SS, Panzer divisions would use as they'd have a shield and they'd put something on the shield as their logo. Interesting. It's updated to 2025 though. So, activism. What have they done lately? Oh, wow. Some of this looks kind of gay. Yeah, this looks all pretty gay. Pretty gay! Just saying, chat. Pretty gay. Yeah, this looks all pretty gay. So, I'm just saying. Here, this is pretty gay. Look, they're all looking for Kyle. Here, look, they're all looking for Kyle, guys. Huh? Look at that. Yeah, they're all looking for Kyle. These guys are, yeah. Okay. Looking pretty gay. That's a lot of guys who are going to hit Odin's spear with each other. Yeah. So. Gay. Gay. Let's keep going. Let's get rid of this gayness off the screen. So, law enforcement were neglected to record Westfall's interview. Yeah. And when asked for an alibi, he claimed he was home with his son. And the 5.5 years later, in Allen's arrest, law enforcement took no further action. After Holder's interview, tipsters repeatedly called and reported him, claiming he posted pictures of a half-dead woman with symbols out of tree branches. The officers investigated the landfill where he worked, showing that Holder swiped his card out of work at 2:45, which is 30 minutes after the bridge guy video. The case invited the officers to review the video to confirm the accuracy, but they declined, nor did they interview other employees because we don't know if he left early. And they said shortly before leave that they received a tip who said, hey, look at Holder's social media. With the similarities between the murders and pictures that this guy put on his Facebook. Young girls being murdered with sticks placed on their bodies. Notice nobody cared about that. There's also the stick formation on Abby and a bind rune Holder tattooed or drew on his hand. Yes. He's like, I'm binding the runes together. I take the rune and this rune, and it's like my Pokemon. I make a super rune. And I'll tattoo it on. And he says, as he told people, that's a bind rune on my hand. I took a Gable rune and an Isa rune, and I made a rune bind. I can't imagine him saying this like, listen, brother, basically I took a Gibo rune and an Isa rune, and I made a rune bind. That just sounds, when you say it either way, it sounds really gay. Listen, brother, I bind my runes together. That says Holder's social media also featured him holding guns and homemade knives. Yeah, don't care about that part. Winners immediately recommended that they investigate him, but they claim his alibi was cleared. They also, Holder displayed paintings he made of Odin upside down. Holder's paintings also described a red Fehu rune or featured it. Winners wasn't satisfied, but no further action was taken. Hold on one second, chat. Was watching TV and somebody was like yelling, and I thought that was her, and I was like, oh no. Is it a Gabo rune? I don't know. It's gay! He'll be like, listen, brother, it's the Gibo rune. Brother, it's the Gibo rune. No, it's gay! It's Gabo! And you're a gay boy! He's like, it's Gibo! Gay! And he's like, it's Gibo! I'm like, you're gay! That's how you deal with these people. You don't like, listen, brother. It's like, is that what you talk to when you're in? Listen, brother, I'm just going to use my Gabo rune. And you're just gonna is that how that works in the woods? Is that how that works in the woods? And just he'll sit there, go home and cry in his trailer. It's the chemo road. Hi, Kurt. Hope you're doing well, man. Having a good Sunday? Good. Friend of the show, friend of the channel, Kurt. But that's how you deal with these people. Well, I'm a pagan. No, you're not. No, you're not. You're not. No, stop. 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 So, you just don't let these people get away with it. So they say an Allen's assistant law enforcement re-examined Holder. And Holder's story about Abby began to change. He said he told law enforcement he never actually met her, but in August of 2023, he told law enforcement he met her once. And during a deposition, he said he met her twice. Well, then what? Well, remember, every other time, if Richard Allen said it, it's a lie, but these are okay. And at least one of those encounters occurred shortly before the murder at Patrick Westfall's house. Why were these girls at Patrick Westfall's house? They say Allen's counsel opposed case, the Liberty landfill person, and found Holder did not have exclusive control over his badge on the day the girls went missing. Yeah. Allen also uncovered evidence that impeached the course of investigation even further. In 2018, Brad Holder told his wife that he had a fight with Westfall because Westfall wanted to up from animal slaughter to a different type of sacrifice. He was like, brother, we're going to play Creed. It'll be our sacrifice that we'll listen to. Then Holder then told her that Patrick killed Abby with others and that she needed to keep her mouth shut. Well, we have a direct inculpation of that. And no, the cops are like, but I'm tired. They didn't investigate. Isn't that awesome, chat? Isn't that awesome that they didn't fucking investigate this shit? Doesn't that make you feel better? You feel like, oh, wow, justice is actually being done. Doesn't it make you feel better? So the evidence shows a shoddy, incomplete, and mishandled investigation. And it raises reasonable doubt that Holder and Westfall were responsible. Allen was entitled to present this evidence to the jury. The judge committed reversible error by excluding it. Yeah, I would agree she did. But remember, I think that the strongest stuff is up front, and this should have been in front of the tool mark examining, because this is far more important. It's far more important. I don't know why they didn't, but hey, like I said, I'm not the attorney on this. The error violated the Constitution, affect the jury's decision. The defendant can attack not only the probative value of crucial evidence on the circumstance when it's found, but the thoroughness and good faith of the investigation. And that's Kyles v. Whitley. And that's a big Supreme Court case with criminal procedure. Here, the evidence created reasonable doubt and raised questions of utmost importance. It said, had the jury heard it, a different result was likely. I think that, yes, that's probably the one thing that would show there's some issues here. And they say the very premise of our system of criminal justice is that partisan advocacy on both sides of a case will best promote the ultimate objective that the guilty be convicted and the innocent go free. Well, and because the trial court prohibited the jury from hearing Allen's side of the case, it shows how law enforcement went down the wrong path. Justice cannot be done. Richard Allen requests his court reverse his convictions. Signed, Stacy Uliana and Mark Lehman. And they say this contains no more than 24,000 words. And there we go. That's Stacy signing for it. They say this is sent through the e-filing, so it should be in. And that's it, chat. That's it. So where does this lead us? Where does it leave us? I don't think Richard Allen wins. I think the courts will find their way to get around all of this. Would I like to be wrong? And you could say it's my pick, my lock of the week. Richard Allen loses his appeal. I hope I'm right. I pray to God I'm wrong. I want to be wrong so bad. I've never wanted to be more wrong on this than anything. I want to be wrong. I want to be so wrong. I want you all to come back and go, booyah, fat man, you got it wrong. I want you to do that. But it's not going to happen. Norster is saying, are we waiting on a response from the state? Yes. This came out like 2 weeks. This came out like 10 days ago. So it's going to take them a while to respond to this. This is like 100 pages. It's going to take them a while to format a response. And they're going to have to read through the transcript too. So we'll see. Caleb said, hey, the Indiana Supreme Court did eventually give him his lawyers back. Yeah, but that was like such a massive fuck up. And the whole world was watching. They kind of were like, okay, yeah, you kind of really screwed the pooch there. They're going to ask for extension. Of course they will. They're going to need an appeal. They're going to need time. It's 100 pages. Richard Allen's attorneys needed a little bit of time on this. So yeah, it's probably going to be a little while. It's probably going to be at least 2 months before this is done for them. And then because remember, you got the holidays, and that's always a problem time-wise for courts. But yeah, they're gonna get the chance to respond. It's probably gonna be 2 months. And then we'll go through that. They're gonna go, that's not true. Or they're gonna say everything was harmless error, which is what they are prone to do in these situations. So if Gull only allowed cameras in the courtroom, well, that would have changed a whole lot. But yes, it would have been nice if she had. It would have been nice if she had. Your main takeaway from this is that penguins are bad. Well, that is not necessarily not true. I've heard penguins can be bad. I mean, look at it. Mr. Popper's penguins, that was a whole criminal empire he ran out of his basement. Hold on one. Everything is fine over here, says, but it's all harmful. But it's not, though. The courts decide it's not harmful. Remember, and I've said this before, and I'll say it again. If courts actually did their job, they would collapse the systems they oversee. Because that's how they work. If they were here to really implode the system, then the system would collapse, and they can't afford to have that happen. They have a job. They have a vested interest in doing a thing and seeing it through. That's what's going to happen here. That's what's going to happen. And I hate to say it like that, but it is what it is. What it is. What it is. Sorry. It is what it is, chat. So just what are you going to do? I don't know what you do when you're Richard Allen, because you're kind of getting boned. You're kind of getting boned. I just don't know how you deal with it. I just don't know how you deal with this, because I just don't think the court's going to allow it. The court waves this magic wand and says it was not harmful. Yeah, pretty much. Pretty much. CD says, I don't know much about this. Is Francine Gold still judging? Yeah, she's the presiding judge in Fort Wayne, Indiana. She is the chief judge of her county. So yes, she's still practicing. So, Midnight in Exile says, Poppers, do I want to know? Oh yeah, you've never read the book Mr. Popper's Penguins? Really? It's a fun book from back in the day. It's a 1938 children's book. I remember reading it in school. I can't believe you've never heard of this book. He ends up getting a bunch like a penguin, like he gets penguins and like he turns on the air conditioning in his basement and he turns it into like a penguin sanctuary, and the penguins like shoot down the stairs and play around on the ice and stuff. Yeah, it's a whole thing. It's a fun book. It's a fun book. Oh. Kathy, you're saying there's no way to get out of this? I don't think so. I don't think the courts are they're gonna accept it. Oh, don't bring up the Jim Carrey movie. It's awful compared to the real, like the book. Hey, it's Ariel says they can test the unknown male DNA found in the girl's underwear, but they won't. They won't. Because they'll say, we got convictions. We got confessions. I get your confession. I'm going to convict you. Richard Allen, count me in. That's what they're doing here. That's what they're doing here. They don't need it. They don't need it. It'd be nice if they did. But there's a reason why they won't test it. Because then they're going to say, fuck, it's not Richard Allen. And then everybody's going to say, then why do we convict him? And they're going to go, hamana. Oops. No, they've settled on Richard Allen. He's the bad man. Noser is saying, will the Supreme Court of Indiana think the same as appeals courts in case the appeals court denies the appeal? Well, ultimately, you are not entitled to an automatic appeal to your court of your Supreme Courts. In most states, that is a discretionary appeal. The court could choose to hear it or not to hear it. So I don't think they're guaranteed to hear it. I think they might accept hearing it solely because Judge Gold fucked up the case so bad that they had to get involved once already. But I can't promise you that they'll want to hear this. I can't promise you that they'll want to hear this. And yeah, like, what do you do then? I don't know. But it wouldn't be the first time these judges go, yeah, we're not hearing this. We're not doing this today. And you're like, wait, what? And they said, you heard me. We're not doing this today. And you're like, but why? And they said, we're not doing this today. And yeah, it's a discretionary appeal at that level. There are times where it's automatic, but this isn't one of those, generally like death penalty cases and stuff. But we're not at that. This isn't a death penalty case. It's a very good question, though. I just do it, dear Maria? No. Yes, 2 other people had already confessed. Carrie is correct. Other people had confessed to this. But they don't count it. They don't count it. Yeah, it's probably Holman's DNA. Yeah, he probably masturbated on it because he's just a fucking queer. Jerry Holman, I hope you're watching this. You're a faggot of the highest order. Have fun at the truck stop tonight, buddy. Kathy says, no, this is horrible. I mean, sorry. I don't, you guys, you know this. I don't gas you guys up. Just telling you the reality of the world, which is sad and it sucks. But yeah, this is probably going to happen. I get the feeling the Court of Appeal is going to say no case, get passed on. The Indiana Supreme Court, even if they take it, says we affirm the appellate court findings, and then Richard Allen dies in prison. Because it's not like he's going to get certiorari. So, sorry. I wish I could tell you it's going to be okay, but I can't promise you it's going to be okay. I wish I could tell you. Yeah, what did we learn? Never talk to the cops. Never talk to the cops. Don't ever talk to the cops. And remember, Richard Allen, maybe Richard Allen's place in life is to be that warning to you. Maybe Richard Allen's thing is for that, he did that. So you guys can understand, really don't talk to the cops. It sucks he had to do that to be part of the universe, making it clear. But yeah, do not talk to the cops. you will only talk yourself into prison. Did Judge Cole order evidence destroyed or just not preserved? She did not order them to preserve evidence. She didn't order stuff be destroyed, but she ordered stuff. She didn't order the state to preserve evidence. So, Mexican Vader says he would probably be working at CVS right now as a pharmacy tech if he just kept his mouth shut. Pretty much. Kathy says you're killing me, Smalls. Well, sorry. Like I said, I'd love to hope. I think everything in here is spot on. It's a banger. It's a certified hood single. It's a certified hood classic. So I think it's just not going to be, I just don't think it's going to work, chat. So I wish I could tell you otherwise. I mean, this is... do I wish it was? Yeah, I wish it was, guys. I wish it was. But, it is a certified hood classic.
This is a certified hood classic.
But yeah. I'm ruining your Sunday. Sorry. Candid Eyes says with a heavy heart, thank you for discussing this course. Hope is frail. Hope is frail, but it's very hard to kill. He's not done. But is he very likely done? Yeah. That doesn't mean it's over all the way, but yeah, it's just going to be rough. It's just going to be rough. Do you think Richard Allen's doomed to stay in prison? Probably. I hope I'm wrong, guys. I want to be wrong. I want to be wrong so fucking bad. I want to be wrong so bad, but yeah. It's Sunday. Yes, it is 100% Sunday. T from Laos says so much for letting may justice be done, or let justice be done, or may the heavens fall. Well, maybe the heavens have already fallen. Maybe the heavens have already fallen on us. Something to think about. So, ruining your Sunday, I'm sorry. So, you're saying it's a snow day tomorrow already, pals? Who's ready to watch the Zach Adams post-conviction hearing? I won't, because I got stuff tomorrow. So I got court tomorrow. What makes me even angrier is knowing these people get away with it. Yeah, well, that's... If you're looking for, if you want to find where the good guys always win, go read fairy tales. The good guys don't always win. The good guys don't always win. Good guys win, bad guys lose. You're reading the wrong stories if that's what you're shooting for. Sorry. Looks like we're for a rough ride tomorrow. Really? Hold on. Because I'm going to be driving tomorrow. I got stuff to do here. Like, ooh, buddy. Uh-oh. Let me see here. Let's see. Right now it's 55. I got some things I can work on. I'm going to have to go do outside. We just got to mop the floors. Louie and Clyde have made a muddy mess in the house. 10 day. Yeah, Monday. No, we're not. Not turning off ad blocker weather channel. Thank you very much. Snow is a chance of 80%. Woo! Okay, but, like, how much snow? That's what I wanna know. Wow, okay, that's, about 1 inch of snow expected? Okay, well, that's not that bad a deal, like, we'll survive. Older fairy tales used to be darker than, today. Brad says, "This is just a build-up of the Sunday scaries." Well, yeah, that is true as well. I just want them to ponder, are these the baddies? Well, they won't. They won't. You're getting 12 to 30 inches. Woo! Woo, 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 woo. Wow. Um, sorry. That's awesome. What will be my sandwich for New Year's Eve? I don't know yet. Um, Tech Guy says I just got back from a week spending time with my folks. Please everything I missed before the Sunday or Saturday before Christmas stream. Sorry, you have to suffer. Ploxer says no. Yes. Let's see. What are the chances that Tyler Robinson's team gets a whole prosecution team removed? Probably none. But you go for it. You try everything you can. You try everything you can. You do whatever you can. In these cases. These cases are so big, you do everything you can in them. So, drop the meatball sandwich. Yes. Yeah, they're trying to get the prosecutor's office removed. I don't think it's going to work. I don't think it's going to work. It's really hard to have that happen, but it always could. It always could. Oh. So, with that said, Chad, I think we're going to wrap this up here. Thank you guys all for hanging out. And yeah, sorry for the red pills. The Browns win. Oh my God, suck it, Pittsburgh. Suck it dry, you Yinzers. Um, y'all got nothing. Oh my God, that's awesome news. That's awesome news. That's awesome news. Uh, woo! Thank God. Thank God. The Browns 13, Steelers 6. Ooh. 17 seconds left. Oh God, who's got the ball? Oh no. First and 10 on the Cleveland 7. I hope that doesn't mean the Squealers have it. So that makes me nervous, chat. That makes me very nervous. The Browns may lose. It's like as easily as they can. Oh, it's over. Suffolk, Cleveland. Well, Cleveland still suffer. We're 4-12. Suffolk, Pittsburgh. You lost to Cleveland. So Cleveland in last place in the AFC North. That's really what we need right now. It's a 4-12. Cincinnati 6-10. Baltimore 8-8. And fucking Pittsburgh 9-7. Oh, so I looked. I jinxed it. Yeah, well, I was told it was over, so I wanted to go look. Are we gonna do a stream? Yes, later today. I have to go take care of some stuff, chat. Gotta get some floor mopping done. 2.0 asked me to do it. I did not get to it earlier, and I was an app. This is a shithead thing for me to do. I said I'd take care of it, and then I didn't get it done. So I'm not trying to guilt trip her. I'm being very honest. I did not get it done. I need to get that done. I need to help her get some stuff sorted out. So and get cleaned up because it's a nice day outside. It's 55. So we will do that maybe later this afternoon. So it's not a messy sandwich. Thanks, Three Beers. Are you guys going live tonight? Three Beers, you and Whiskey? Unban you on the model bench. Okay. I didn't realize you were banned on there. Did I see the casino covering quartering at Amfest? Yes. It's hilarious. But Three Beers, are you and Whiskey going live tonight? Uh, can we watch Vivek's talk on the model stream? Sure, we could listen to that. Okay, probably New Year's Day. Okay, so no assholes we had tonight. We could go live probably a little later this evening and hang out, guys. But for right now, no. Not for a while. It's a couple hours. It's already 4:00, so we'll come back to it a little bit later tonight. So, chat. Remember, till next time. Just because you did it does not mean you're guilty. And for Brad Holder, Patrick Westfall, and all the other ownness, even though they did it, they're not guilty. Yeah. So sadly, like I said, guys, I don't think Richard Allen is going to turn out well. But like I said, I want to be wrong. I want to be wrong so bad. I want to be wrong so bad. So, anyways, good night, chat, and I will talk to you guys later. Good night, everybody. Thank you all for being here.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney.